do so. Well,
First time the late started meetings.
Is Joe going to be with us from every meeting now?
I'd like to call to order the September 7th regular meeting of the Keel Island Planning Commission. Could you call the roll, please?
Mr. Peterson?
Here.
Dr. Hollingstiller?
Yes.
Mr. Daddy?
here.
Mr. Kelly?
Here.
Mr. Iwan?
Here.
Ms. Kay?
Here.
Ms. Hennessy?
Here.
Thank you. The first item on our agenda, item 3, the approval of minutes from August 3rd. That's under tab 1. Could I have a motion to approve
So moved.
and a second?
Second.
It's been moved and seconded. Are there any comments, corrections, changes to the minutes as presented? Hearing none, I'll call a vote. All those in favor say aye.
Aye.
Opposed? Thank you. Item 4, public comments, agenda items only. Did somebody check see if anyone signed in?
No.
No one signed in. Okay, we had a system where they will sign in prior to the meeting outside if they wish to make comments on agenda items. Item 5, old business. Planning Commission rules of procedure proposed amendment. John, do you want to say anything, or should we just?
So just to recap from our last meeting, we did make some proposed changes. What is before you today in your materials is staff recommendation regarding the rules of procedure. I can walk through all those, sort of the substantively what has been recommended for approval if you want to. So going just by Article 1, organization under section number 7, there are two things. One is to be able to modify the rules of procedure to allow email as a way of notifying members of materials. And then secondly, the item G is modifying the 400-foot radius to 300-foot radius that essentially marries what's in our zoning ordinance. That's the first thing. Going to Article 2, and Mr. Chairman, we can take these section by section if you would like, or you want me to kind of review the entire proposed changes.
Why don't you just go through it
Okay.
all, and then
Okay.
we'll do it section by section, I
Okay.
guess.
Article 2 under meetings, under section 5, this was recommended by Commissioner Hennessy that we codify essentially our practice of allowing members to participate virtually as being a member eligible to vote on matters of the Planning Commission. And so section 5 and section 6 adds language specifically to that ability for planning commissioners to participate virtually via video conferencing and them being able to be present. Section 8 is regarding executive sessions. We've added language in here regarding the expectations of how executive sessions and planning commission members are to conduct themselves regarding executive session meetings. And the final section really stemmed from a workshop training that we had as a planning commission regarding ethical standards and professional conduct. And so there are a list of aspirational standards that have been included. This marries or models rather another chapter of American Planning Association, their code of professional conduct. These are aspirational standards. And so these are things that would be expected of planning commission members, not necessarily enforceable or required, but however, these are aspirational standards as a public entity, a public official of what staff has reviewed. If any of these that the planning commission doesn't feel that warranted, we can modify the language or completely strike those as you deem appropriate.
Thank you, John. As John said, this is the staff recommendation, so I would ask for a motion to approve as presented, and then we can make amendments
So moved.
as required. Thank you, Andy. And a second?
Second.
It's been moved and seconded. Are there any discussion about these items?
Ms. Hennessy has,
Joanne, I see, I'm sorry. Yes, ma'am.
Yeah, I had some issues with a couple of things. First, in executive session, it says it is unlawful. What does that mean? To what law is it referring? If you're saying something's unlawful, then you have to have a law that you're talking about, and I don't think that exists, so I think that word should be removed. You know, the privileges and all that
Well,
stuff, that's fine.
let's address that right now. I mean, let's do one at a time. Mr. Wilson, do you care to say anything about that?
That language is borrowed from our own code of ordinances, the ordinance that governs council meetings. Unlawful simply means it's a violation of law. It's not within the prerogative or purview of planning commission members to violate the town's attorney-client privileges, or, well, any executive session privilege.
Well, I still have a problem. When you say something is unlawful, it has to refer to a law. You know, is there an executive session is required under state law or town ordinances? I don't think so. What does it mean, substance? You know, we don't violate attorney-client privilege, but the word substance, I just think this thing is way too vague to have meaning. We can say, you know, you don't talk about what the attorney told you, even though the privilege is really with the client, but fine, we don't talk about anything that was the attorney-client privilege. But what do you mean by substance? Because we're really not supposed to talk about other things other than receive advice from attorney. The other issues really are supposed to be done in public, if, you know, in that whole, all this other stuff about transparency. So, yeah, I don't think, if you're saying unlawful, you gotta cite a law. And you gotta be a little more clear on what substance is.
Again,
Joe, did you say this is from our code of ordinances?
it mirrors the language that town council operates under. It is unlawful, again, when you go into executive session, that is done by majority vote.
Mm-hmm.
And that is the decision of the planning commission. So
Right.
once that happens, that executive session privilege for a member to violate that after a majority has decided that this is an appropriate conversation for executive session would be violative of the law. You would be
What law?
removing, well, now hold on. You would be taking away planning commission's ability to conduct executive sessions. And I don't know any other way to put it, and it's something that's in our code already. But, you know, if you want to make a motion to amend to a different wording, you're certainly entitled to do that.
Yeah, because I mean, I've been dealt with executive sessions before, and they're usually restricted to receiving advice of counsel, discussing personnel matters, discussing contract dispute, you know, contract issues, or any pending legal litigation. Those are valid things for the commission to recuse themselves into executive session. But again, then I'll make a motion to take out the word unlawful, because if you say unlawful, there has to be a law, a state law, some sort of law that you're violating, because that's pretty serious to violate a law.
You need to make a specific amendment.
Okay. you know, actually, I don't like a lot of this wording, but I will make a motion that we eliminate the unlawful, it is that a planning commissioner should not disclose any confidential, you know, we can say attorney-client privilege information. I have problems also, and maybe somebody else can chime in on this as well, with the word substance. What does that mean? You know, when you talk about substance, because some of the things discussed in executive session may have been more appropriate to discuss in public because they were not attorney-client privilege, contract, personnel, et cetera. So I think we can get ourselves into trouble here, and it's vague. I'd like to hear some other opinions on this.
Joanne, would you repeat the motion you're making?
Motion, what amendment?
You know what? Before I make a motion, I'd like to hear. You know, I've said why I think this whole section has some problems with it. I would like to hear what other people, when they read it, what they think.
Oh, Michael, I'm sorry.
I mean, I find the wording of that section also troublesome. I understand the purpose, I understand the intention here, and I think that's the right thing to do. Using the word unlawful, I would agree with Joanne. I think it's a very strong word, especially if it's just standing there without reference to, for example, some kind of, you know, town council regulations or whatsoever. So I would probably want to also suggest to take out the word unlawful, maybe do it, substitute it by something like inappropriate and then make a reference to what Mr. Wilson was saying in terms of, you know, what it is referred to become inappropriate, or in his words, unlawful.
Well, so is your motion to amend to change unlawful to
Inappropriate.
inappropriate?
That would be
Okay.
my first part of the motion, and the second part is that I would include a reference to what Mr. Wilson said in terms of the town council, the rules and regulations, or the ordinances.
Well, is that a law of the town of Keel Island, an ordinance?
There is an ordinance that states it is unlawful to disclose, that says the exact same thing. It says,
Okay.
so,
I just make a reference to
you
that.
can make a motion to amend to say whatever you want.
Do we have a second for Michael's motion to make it is unappropriate for a member to disclose blah, blah, blah?
Second.
Okay, Joanne, you've seconded. Any conversation about this?
The thing that concerns me is the fact that the executive session is a result of a majority of vote of the planning commission to go into executive session, and you know, and then the word of inappropriate. I understand the point about unlawful, but the word of inappropriate doesn't seem strong enough. I think what we're trying to protect is the confidentiality that's taking place by that the majority of the commission has authorized. And what we don't want to have happen is that individuals, based on choosing personally to be inappropriate.
Joanne?
I think there's something, you know, in all of our training and in all our ethics requirements that I think when we went through training that were required as for, you know, municipal representatives, that executive session, we are expected to maintain the confidentiality of the confidential things that are imparted during executive session. I think we are all bound by that. Question, because, you know, when you talk about unlawful and substance, for example, our last executive session, we talked about a lot of stuff, and we did receive attorney advice, which I assume none of us has discussed. But does that mean we are not allowed to talk about the justification for the, not one of the 7 of us talked in public about why we voted the way we did. And I think any of us could do that to explain our yes or no votes without violating attorney-client privilege, because we don't have to talk about what the attorney advised us. So I have a little problem with substance, and I just want to make sure none of us, you know, that we are all abiding by what we're supposed to with executive session, but not being hamstrung by things that aren't confidential.
No, well, first of all, I think your word is, I like your word better. It's expected that the members of the planning commission will maintain confidentiality as required by the town council, or something of that nature. You know, as the town council ordinance would be a way of, I think, avoiding the word unlawful and getting to it. What I do have a problem with, though, Joanne, is that the way you proposed it, it sounds like individually we each can make a decision as to what is appropriate or not appropriate to be considered under counsel or not
Attorney.
client attorney privilege. But the point being is that an executive session is not an individual activity; it's the group activity.
Right.
And I think that we want to make sure that we don't give the impression that it's up to us individually to decide what is or is not under. Maybe you didn't think your vote wasn't affected by something that the attorney said. Maybe my vote was, and I think that's got to be maintained in the secret, not the secrecy, but the confidentiality has got to be maintained.
Jim, just a reminder, we do have a motion to amend on the floor, change unlawful to inappropriate.
Mm-hmm.
So,
Or
let's
how
not
about,
lose sight of that, please.
Right.
how about, rather than unlawful or inappropriate, what if we said it is a violation of town ordinance?
Madeline, I think we've got to call the question before we consider another amendment.
Unless you want documents to withdraw.
I would also be appreciative of what Madeline said, because inappropriate, I agree, could be, you know, give rooms for interpretation, right? But making a strong reference to where actually, you know, it is written what we have to obey to, the confidentiality of anything that was discussed during the meeting, that's okay with me.
So, are you
So-
going to withdraw your motion?
If Madeline wants to file another motion with her proposal, then I would withdraw, yes.
We've got to vote on this first.
No, he can withdraw his motion. He can withdraw his motion. with
Yeah,
me.
she's got, both of them got to, if they want to.
What?
They both got to withdraw, the second as well.
Joanne, are you okay with withdrawing so that
Yeah.
Madeline can make a replacement motion?
Joanne?
Joanne,
I'm sorry, say again?
are you willing to withdraw the motion so that Madeline can make a replacement?
Sure. Yes,
Thank
absolutely.
you,
I was.
thank you. So Madeline, do you want to make your,
So I move that in section 8, executive sessions, we replace the word unlawful with the words a violation of town ordinance.
okay. Can I have a second for that?
Second.
It's been moved and seconded. Any more comments about
I'd
this?
just like to know, I want to make a note of what town ordinance, just so I know.
I think for our, this is our rules and procedures. I think if we have saying it's a violation of town ordinance, that's sufficient. I don't think we need to, that's Madeline's motion, so if we could have a second for that.
Second.
It's been seconded by Dr. Hildenfeld. Any more comments about Madeline's motion?
Well, I would also agree that we can just eliminate substance of.
No, we can't do it
Let's
that
do
way.
it
We
at a
can't do it that way.
Do one motion at a time.
Okay, fine.
Okay, so We're changing unlawful to a violation of town ordinance. Remember, blah, blah, blah. Everything stays the same. All those in favor of that modification, please say aye.
Aye.
Opposed? Thank you. Okay. Sir, you had another,
Well, I just was referencing to what Joanne said earlier with substance.
well, I think we,
I would just say public, or make public the matter discussed. I don't
doesn't that say
understand
the same
substance.
thing, the substance? I
I
mean,
don't understand the word, or why there is the word substance in the center, because.
so
if I
to make
understand
public
correctly, we
any
are-
matter discussed?
Yeah,
Okay.
I thought that's the rule for an executive session, that
Right.
whatever is discussed in that session cannot be disclosed to the public.
Okay, so you would delete the substance of, to make public any matter discussed in executive session?
Yes, sir.
Okay. Can I have a second for that?
I second it.
It's been seconded by Larry Allen. Any further comments about that?
Wait, could you say again, what is the motion?
The motion is to make public, taking out the substance of and replacing it with the word any, to make public any matter discussed in an executive session.
I think I have a problem with that. Any matter, because what about if while we are in executive session, we discuss things that really should be in a more public purview?
We shouldn't do that. We won't do that.
And
We've only had, to my knowledge, one executive session of the Keel Island Planning Commission. I think that this modification certainly serves to make us all on notice that we should not share what we heard while we were in executive session.
I agree.
Any further comments about this
I
amendment?
had trouble hearing what you just said.
If I may just make a comment on the technical aspect of this, the virtual piece of this. Everything that Joanne and I are hearing from the podium is very, very clear from where John is standing. It is more difficult to get clarity from the microphones that you guys have up on the dais.
I apologize for that.
I apologize for asking as well for certain things to be repeated, and I'll be back live next month, but for now, just so you guys understand, it's blurry sound coming from the dais. It's very clear coming from where John is.
Well, and actually, like Michael, I can hear. Larry, I think, was the one speaking. Fred, you're the one I'm having trouble hearing.
Yeah,
Okay, well, I apologize.
well, that was a little better, Fred.
Okay, well, maybe this other microphone wasn't working.
That's better.
Is that better?
Yes.
Thank you. So we have a motion to remove, that's loud, the words "the substance of" and replace the word with "any." Are there any other comments at this time on this motion?
Okay, wait, so you want us to make public any matter discussed in executive session?
That's correct. Anything in executive session is privileged and confidential.
How about any privileged? I would go with any if you add the word privileged.
Joanne, we've already have a motion on the floor. You have to, if you're opposed to it, you can say you're opposed to it.
Okay, who made the motion? Was it Madeline? Did you make that one? Who made that motion?
I think I did.
Michael did and Larry Iwan seconded it.
And Joanne, I think I understand where you're coming from, but if we would add confidential, then again, we open the door for interpretation.
Correct.
So if we go into an executive session, the topic at hand or the matter at hand seems to be crucial and need to be remained, confidential. So I think that any matter discussed in the executive session should be treated highly confidential, maybe with the exception, Mr. Chairman, that the chairman could allow a certain part of the discussion to become public.
I'm
But
not
would-
comfortable with
I
that.
would think
Making
that's
that
also
decision,
against the
I'm only a
reason
spokesperson
for
for
an
the
executive
commission.
session, right?
Okay.
So,
So we will have a vote on the motion to replace the substance of a matter with the word any, A-N-Y. All those in favor say aye.
Aye.
Opposed?
Oppose.
Okay, Joanne. Madeline?
I'm all right with it.
Okay, good. Well, that's been approved now. Are there any other amendments to the staff proposed document in front of us?
I just have a question for clarification purposes. Michael had made several suggestions in an email format, revisions, suggested revisions, and I'm not sure if those have all been incorporated into the document that we're looking at.
Well, I guess we can let Michael speak for himself, eh?
yes, Madeline, thank you. So I think the first topic in my email has resolved itself because we have no topic on the agenda for the beach walker parcel.
Pertaining to the rules,
Section 7 with the 300 feet on Article 1 instead of 400 feet is, I think, also okay from my point of view because it aligns obviously with the zoning distance, with the zoning ordinance in that respect. I think topic number 3 in my email, I agreed with that, to find a way of saying that the town is committed to provide better audio.
Okay.
Has that been included, John? I'm sorry.
so none of the things that were sent ahead of the meeting were included. You would need to make that motion to amend to include that in.
Okay. So then, following up on this, I would like to put the motion down for Article 2, Section 7. That there's a sentence something like that the town is committed to make any possible effort to allow an uninterrupted and productive virtual session of a commission meeting, but the town cannot guarantee that members attend virtually will be able to hear everything that is said. So something like,
Michael, did you see Stephanie Tillerson's email regarding us committing town council to spend money?
and I
And we
wasn't
can't
sure
do
that
that.
I really understand what she was saying, sorry.
Okay, well then,
Or what she was trying to say, let's say it this way.
Joe, if you wanna-
The planning, and I will comment on, the planning commission cannot commit town council to spend money or really do anything. I mean, in a code of conduct for the planning commission. So it's just not the way it works.
Right.
I can just comment just quickly on that. That's what I was saying. Sorry, I have my shoes on. But one thing I will just like to let you all know is that the town council has already approved in this budget to look at our system here. So Michael here is working on that. So it's not something that you can put within your guys, but the town council, their meetings are live streaming. So they are working on doing upgrades to our system. So, but we can't put anything on here to commit the council to spend money.
Okay, understood.
so you withdraw?
Yes, sir.
Okay.
was
Anything
not
else
aware
in
of
your,
Well, and then I have a little bit of an issue with Article 7, Section 2, I believe, under the headline of loyalty, the second last bullet point. I don't oppose final decision once they have been made by the decision makers, except through internal lines of communication. And as I outlined in my email, I think that violates my rights of free speech.
Michael, can we wait on that one until we discuss the first section which has been changed and replacing Article 7?
Sure.
you have something, Andy, you want to propose?
Well, in effect, the amendment I'm suggesting would replace Article 7 with the preamble, and the preamble includes a number of items. I'm more than happy to suggest, in my mind, all 7 that are listed covers everything that was previously in Article 7. And if those items now listed under the preamble are satisfactory to replace Article 7, I don't think we need Article 7, nor do we need any changes. But if there's something in there that you don't think is covered by any one of the 7 items, I'd be happy to consider any adjustment there. But this is the same language and the same information we got at the training session and under the discussion of the trustworthiness. And it really, it's a preamble to all of the rules. It's something that the commissioners should follow, and it's not a rule per se of the meeting. It's a rule for commissioners to understand, or position, principle that members should adhere to. But having said that, Michael, I don't think there's anything in here that would conflict with any position with respect to loyalty or freedom of speech.
No, as I mentioned in my email also.
So that would eliminate
It would.
the need of
It would.
anything in
Question
Article
is-
7.
Question is if
Right.
this is really fully comprehensive, your list, which I think is a really, really good start, putting it right in the front, I would also support, because these topics are very important for a professional conduct in this committee. The question would be if there are any other bullet points that we would need to add.
So is that a second to my amendment? A second to my motion?
Sir, yes.
Okay.
Great. Joanne?
Yeah, I just pulled up and I was reading Andy's 7 points, and you want to make them a preamble to Article 7?
No, a preamble to the entire Article 1.
It replaces
preamble.
Article
You know,
7.
when I look at that, I mean, I think all of these trustworthiness, fairness, there's a lot of redundancy in a lot of these things, community best interests is the same as community quality of life. We're all ethically bound not to have conflicts of interest. That comes up several times in these things. I think they're redundant, and I think these 7 points pretty much sum up. I just find there are so many things in here, and yeah, some of it's mom and apple pie, and I understand they're aspirational, but I promote intelligent innovation. What does it mean to improve existing paradigms? There's a lot of stuff in here that doesn't really have any practical application in my view, and I'd be happy with just Andy's 7 things, You do your best, you listen to other people, you support the town, and you don't have a conflict of interest.
Joanne, that's the proposal. We remove Article 7 in its entirety and replace it with the preamble.
Oh, that's what you're saying, just take away all of Article 7?
Yes.
Right.
Oh, okay,
Yeah,
good.
Andy's
Like-
motion is to remove Article 7 and replace it by starting with a preamble before Article 1 organization.
Right.
And the preamble, as he explained in his email. Any other comments on that request, motion?
I
Michael?
would have.
Okay,
So
Michael.
first, would it be possible maybe to also use Section 1 and Section 2 of Article 7 in this preamble? Because, these two text portions at the very beginning of Article 7, because I think that's also very important to state. And then my other question to the Commission would be if we really are fully comprehensive with those 7 points, or if there aren't some bullet points in the current proposal that should also be part of that preamble.
Michael, the first paragraph of this sentence basically is Section 1 of Article 7. Should adhere to the following values when serving the public interest. The second is really just the introduction to the articles that are listed, and I've said it basically in the same sentence in under number 2, which precedes the preamble. So and again, I understood your
so-
earlier comment to
okay.
accept the fact that we're going to replace Article 7.
Got it. So you are, what is in your email under number 1 and number 2, right on top, would also go into the preamble, is what
No.
you're saying?
No, the first sentence of, under integrity would be the lead-in that replaces Article 1, or Section 1 of Article 7.
No, you lost me.
You've lost me, Andy. You have, it was very clear when you said you wanted to put the preamble at the start and delete section 7.
Correct.
Delete section 7 or all of Article 7?
Article 7.
Article 7.
Article 7. So all this long list of stuff we're getting rid of is your recommendation.
And replacing it with his preamble, principles of serving and standards of integrity.
Okay, so we're replacing these however many 30 different bullet points with Andy's 7. That's the recommendation?
Correct.
Yes.
Okay.
And I would point out that we're going to be reviewing this again in January when we pass our rules and procedures. So at that time, if we think we've missed something, we can always make an adjustment. That would be my thought.
Yeah, I've interpreted all of Article 7 to be included in one of the 7 points we've got listed now in the preamble. And if you find any between now and January, I have no qualms about considering that and adding it if necessary.
So are there any other comments on Andy's motion to remove Article 7 and put in preamble
That's it.
at the beginning of the rules of procedure?
But if you have that language, could you add that language as part of your motion that was, what
Do
you
you
have?
want him to read the entire preamble?
It kind of needs to be on the record, since it's not on the record. Either read it, or I suppose,
You want me to read the whole section?
I don't know how big it is.
It's not,
It's
This part here,
about half a page, quarter of a page.
this part.
you can do it, Andy.
Yeah, please read, it's not in the record, frankly, and it needs to be.
Okay. The motion is to add a preamble to the rules and regulations of the Planning Commission, replace existing Article 7 in the draft being considered with a preamble which states the principles of serving and the standards of integrity for, if you want to add 4 members of the commission, that's fine. But principles of serving and standards of standards of integrity. A first sentence would be, members of the Planning Commission should adhere to the following values when serving in the public interest. Number 1, remember that their role is first and foremost to serve the community. Number 2, be at all times truthful with my colleagues, the public, and others. Number 3, avoid any actions that would cause the public to question whether my decisions are based on personal interest instead of the public's interest. 4, do not accept any gifts or any special considerations because of my public position. 5, do not knowingly use false, inaccurate, or biased information in support of my position. And number 6, do not use their public position for personal gain. 7, carefully consider any promises made and keep them.
Thank you, Andy. Are there any other comments at this time about his motion?
I would like to add, Andy, if you may, the first bullet point under respect in the town staff's proposal. I treat everyone with courtesy and respect, even when we disagree.
Well, you could do that in January, but I'd say number 2 covers that. Courtesy and respect is subjective, and I'm not sure that one might interpret a criticism as being not taken with the intent of changing or with the intent of asking for a reconsideration of an issue, but merely taking that criticism and claiming he or she was disrespected because the comment was made.
I think the problem is we've come off the reservation. We started off with rules of planning of procedure on how we're gonna operate. Now we're getting into rules of behavior. That's a completely different, it's a whole separate issue. I think all these conduct and ethical standards should have been considered when the town council agreed to appoint somebody to the
No question, but there's no reason that they shouldn't be reminded of that
fine.
every time they read it.
You know, fine.
I mean, we have a motion to amend.
Well, he's speaking to the motion, he's opposing it.
All right.
Any other comments on Andy's motion? You, I guess, withdrew your comment, Larry, or?
Well, yeah, go ahead. I withdraw my comments.
Okay, good. Any other comments?
No.
All those in favor of Andy Capelli's motion to remove Article 7 and replace it with a preamble to Article 1 organization, please say aye.
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 Opposed?
Opposed.
Okay. One opposition vote. Thank you. We will,
I'd like you to consider the second recommendation I've made with respect to a change in Article 2, Section 5, under the section dealing with voting. The addition to the section would be to essentially substitute for now paragraph 7 of the draft, and that would read as follows. In the second sentence, we would add a member attending virtually via video conferencing, teleconferencing, or web conferencing is considered present, period. And that would modify the change that's been proposed in Section 5. And that would allow, I believe, and we can discuss it separately, but I believe that would not necessarily, but that would basically eliminate the need for a paragraph 7. In addition, since there have been some questions as to exactly what the language meant, and the addition of added comes from Q&As from Robert's Rules, and they do modify it slightly differently. In their response to the Q&A, they say teleconferencing, and then it's followed by parenthesis, only audio, and then video conference, and then with respect to web conferencing, they say, with respect to teleconferencing, it's only audio. With respect to video conferencing, it's audio and video. And with respect to web conference, it's audio, video, and content sharing. So those are the three definitions which expanded. If you want to add those parenthetical explanations, I'm not opposed to it. I didn't think it was necessary, but that would, again, allow for the elimination of paragraph 7 and cover all of the conditions that we discuss in paragraph 7 for remote meetings.
is there a second to that motion?
I think, Andy, the language you proposed is a lot more clear, simple, and I'd go with that.
Is that a second?
Is that a second, Madeline?
Yes.
Yes, it's a second.
Thank you very much.
Could you repeat now, because there's been back and forth, exactly what the motion is to eliminate section 7, and then how are you wording the change in section 5?
Section 5 would read, and do you want to consider with the parenthetical or without it? Without it,
You
okay.
to add the
Because we have
parenthetical.
Robert's Rules of Order in our
You know,
section 4.
Section 7 would read simply,
Section 5, Andy.
I'm sorry, Article 2, Section 5 would read, following the word voting, I'm sorry, a member attending virtually via video conferencing, teleconferencing, or web conferencing is considered present. That would be an amendment to the now second sentence of the draft Article 2, Section 5.
Okay, and that eliminates the need for section 7.
And that would eliminate basically the need for Section 7 Paragraph 7 completely.
The only,
Just as a point of clarification, is that your motion then to also eliminate section 7?
We can, yes.
Yes.
We can make it in the same motion, or we could separate them. My suggestion would be to make it in one motion.
Well, it's your motion, so, but that is your motion.
Yes.
Mr. Chairman, I also wanted to add that section 7, with earlier debate on the last sentence of, that would eliminate the earlier debate on the last sentence of section 7. So
Correct.
just be mindful of that.
Thank you, John. Are there any comments on Andy's motion as seconded by Madeline? Hearing none, I'll call the question. All those in favor of Andy's motion say aye.
Aye.
Opposed? Thank you. Are there any more proposals for our rules of procedure?
And behavior.
Hmm?
Snarky.
Oh, okay, being snacky. Very good. I guess we're done with that. I guess we need to vote on the main motion, which is to approve the rules of procedure as amended by the previous motions that were approved. So if I could have that motion to approve the rules of procedure as amended.
So moved.
And a second?
Second.
It's been moved and seconded. Are there any further comments on this issue? Seeing and hearing none, I will call the question. All those in favor of modifying the rules of procedure with the modifications, amendments, the motions we made today, please say aye. Aye. Opposed? Thank you. Our next item under old business, zoning ordinance text amendments. This is to grant the planning director the ability to make small amendments to the setbacks for generator stands. John?
Yes, this was initially introduced at our August meeting. No decision was made at that meeting, and so it's been brought back before you for today for consideration. Town has experienced an increase in the amount of generator requests on the island, where it has presented the issue of a lot of these generators being placed in setback. And so from a staff perspective, this particular request is asking that you consider a little bit more relief for the planning director to make some determinations based on conditions. This is similar to what is included already of how we administer HVAC stands and upfits, of those being able to encroach into the side setback by 5 feet. And so these are just a couple examples of minimally encroaching generator stands that have been gone before the Board of Zoning Appeals, all of which were approved. Here you have an example of 63 square feet, 15 square feet, 7 square feet encroaching. So these are minimally encroaching to the setbacks, either side or rear. And so what has been outlined before you in the materials is allowing some conditions to be placed for these to be administratively approved. I want to also remind you that this would still require approval for a zoning permit, so it wouldn't, and this would also require approval for building review as well. This would apply to only 5 feet of encroachment, so if it goes beyond that, they still would need to go before the Board of Zoning Appeals for approval. And the other condition that was placed in there, that the generator should be adequately screened. That's also a requirement of the Architectural Review Board, that these generator stands are screened. This does not exempt them from lot coverage requirements, so if they don't meet lot coverage requirements, they still would have to have a variance for that as well.
And it only is upfits, it's not new construction.
Right, so if this is a new construction where a generator is being proposed, that new generator would need to meet the regular existing setbacks on site for that property. And so I've outlined that this does meet the approval criteria from staff's recommendation. And so you have the ability to make a recommendation to council, you approve the conditions, or deny. I can take any questions that you may have.
Are there any questions of John at this time?
Yeah, I have a question. I can't see who I'm.
That's okay,
Anyway.
we can hear you.
Am I,
We can
Should I
hear you,
ask-
We can hear
Joanne.
you.
okay, I can't see anything other than his thing. Yeah, I just have a question with the section 5, when it says, you know, with the setbacks, and I have no trouble with any, it said, but when the word all of the following conditions are met. And I say this because I was one of the generators in 2021, and we had a very small encroachment. And it says, the generator, in part B, the generator cannot be reasonably accommodated in compliance with the setbacks required by otherwise applicable zoning requirements. In point of fact, in our house, we could have avoided the small and with just a few feet encroachment if it had been put on the front or the other side, but the ARB, and we agreed that made no sense to put it in the front of the house or on the other side because of where the gas tank was located. So I just worry that the word all might have some unintended consequences. It would have in my case. That's all.
So I want to just be clear that this would only allow the administrative approval for these being located in the side or rear. It wouldn't include a front siting location for a generator.
And if it's more than
Okay,
five
But I mean,
feet,
if
it's
we
got to
could
be,
have put it on the other side of the house, I believe without an encroachment, but that was, we wanted to put it on the side of the house, which was very close to the gas tank for the propane tank for fueling. And the ARB and everyone said, yeah, this is where it makes sense. I just want, you know, I don't have a problem with this. I just worry if someone else has a similar, situation on their property, the word all might, now maybe they could just get a variance, I don't know.
They
I
can
just wanted
always
to
go
bring
and
it
get a
up because
variance,
that was
Joanne.
Variance.
It doesn't prohibit them, they can go and get a variance if they need to.
Trying to put an undue burden on people, that's all.
So John, what exactly is the language you're proposing? Is it proposed text amendment AZ 0022-0003?
section 64, 1264.
12-64. If you, in your materials, the second sheet, the final sheet of, that would be tab 3, I think.
Oh, got it. I apologize. I was in the wrong place.
John, the question as to whether or not this applies to new construction? Would it apply to new installations? What about replacing installations that currently exist?
So this would not apply to new construction. So when I say new construction, if a new home is being built and that plan has a generator included in that plan, that set of plans, that generator would need to meet the requirements of setbacks.
Okay.
If this is a generator stand that is being added to an existing home, and they would like to add it, and it encroaches in that, that would qualify for this particular section.
Okay, and what about one that was already installed and is going to be changed? Or I guess you'd consider that a modification?
Yeah, and
Okay.
so if, I guess it would depend on if that generator stand is already encroaching. If they're replacing it in the existing footprint, it would essentially be allowed.
Thank you.
Thanks, John. Any other questions of John?
No.
Just, can I, as a point of clarification, you got a blank for a date there, is that date gonna be the second or the first reading?
It would be an adoption date, so second reading of council.
Just,
Yeah.
I have one other question.
Yes, ma'am.
It's just about the adequately screened is determined by the planning director. How does the ARB fit into this? Because, again, when I did mine, it was the ARB who took my deposit and said what to put in, and, you know, they seem to be in charge. So I just didn't want any conflict of, from the point of view of the homeowner. Is it John who's telling you what trees to put in? Is it the ARB? Because the ARB still requires a deposit
Prior,
before you do it. So I guess I'm a little unclear on, for the homeowner, who do they go to?
prior to a zoning permit approval for the town, they would require architecture review approval. And so you would essentially have the approval of the architecture review board for those requirements of planting, screening. During the zoning permit review, that's when the town would look at the standards for adequate screening. So it would essentially go to both entities.
Okay, and that's new then, isn't it?
No,
No,
it's John and the ARB.
Yeah, that's not new.
Makes things just easier.
Okay.
This is merely in the guise of a recommendation to town council. Town council will make the final decision whether to approve or not. Any other comments on the setback requirements for generators?
Not so much to the setbacks, just to generators. Two things. One, since this is an unusual equipment still, I would like to find a good place, maybe not in this ordinance, but maybe somewhere else, that neighbors need to be pre-informed about the attempt to put in a generator. And second, can we somewhere find a place to limit the noise of a generator to 60 dBA? Which is the usual, I believe, noise
Michael-
emission of a modern generator.
Michael, if I may, I think you're talking about something that's different. than
It's
that.
not, I don't think it fits in here,
Right,
but,
if
you know, as a
if it's
general
something you
comment.
want the planning commission to consider, we can have staff to work on it and bring something forward.
Maybe we need to amend the noise ordinance in that
I-
respect,
I-
because we didn't think about generators at the time.
Mm-hmm.
But I know that it's not, Fred, I know that's not a good place to put it.
We can look in,
But I
I
think-
can look into that.
We want to find
Okay, I
a
think
way
John can-
for the town to
John can do
make a
some
clear
research
rule on
and
this as
see
well.
where we're at.
Okay.
Okay,
Thank you.
good. Could I have a motion to recommend to town council the approval of this setback requirements for generators?
So moved.
And a second?
Second.
It's been moved and seconded. Any further comments
Joanne made it.
on this request?
Joanne.
I was unclear as to who said what.
Okay, thank you. All those in favor of making this recommendation, please say aye.
Aye.
Opposed? Thank you.
Fred, can I ask a question of Michael, our engineering expert? Michael, with all the information we've gotten, would there be any Generac or any type of generator that you're aware of that would qualify or that you would buy and put in the house?
Yeah, because I mean, 60 dBA is basically the noise level of our discussion here.
Okay,
So that's a very normal.
so that fits.
That fits. My comment was only made, there are other manufacturers like Generac from maybe out of the country that might not fulfill the 60 dBA noise limit. So that's why I think it might be a good idea to look at the noise ordinance or something to manage that. But a modern, US-made generator, I think they all claim to be about 60 dBA, and that's I think a very acceptable noise level.
Yeah, that's helpful to me because I'm considering one, but I appreciate that. Thank you.
You're welcome.
Great. Our next item of business is under 6, new business, zoning ordinance text amendment about accessory uses, buildings, and structures. John, do you want to?
Yeah, so I won't necessarily go through the entire list of materials. Staff has made a pivot and request that we do study this a little further based on conversations with the Architectural Review Board. But I thought it would be beneficial to at least introduce the sort of the precipice of why this is important for us to consider.
Does the ARB wish to address the commission about this? I mean, they've sat here for an hour. I just hate for them to.
Sure,
Come on, Amanda.
if they want to.
We can field questions.
Okay. And so
This is not for a recommendation.
So
today.
I'm not
This is
asking
a
for a
background
recommendation of,
information.
I'm not asking for a recommendation today.
Okay.
The issue at hand really is how accessory structures are located and sited. Right now, our ordinance requires that those that are placed in the front of a principal structure be done so administratively. However, if they are back up to lagoon, beach, or critical area, that they would require a special exception for approval for those sightings. And so today, there have been a number of instances or cases that we've seen come through the zoning permit office requesting administrative approval by sort of a skirting of the rules by the definition of how these accessory structures, accessory dwelling units are built. So right now, whether they're detached or attached, that connection is how they're determined. And so right as you see, I'm gonna just go to the examples that I've shared you in your materials. I think that kind of communicates a little easier. The accessory structure you see in this first example, the principal structure is here to the plan south to the bottom of the screen. And what the architect has proposed here is a wall connection that essentially connects the principal structure all the way down this wall to the accessory structure or accessory dwelling unit. And so by definition of the ordinance, this is a wall connection, but it really reads two separate entities, two separate structures, right? It doesn't really read as a single structure as the intent of, I think, that may have been written when this originally was. Another example here, so this is an example that actually came before the Board of Zoning Appeals for review. Here to the left of your screen is the accessory, is a porte-cochere where cars would drive under to get to the principal structure. This was actually voted down at the BZA, and what the applicants decided to do was just essentially, this is that porte-cochere here example. The applicants just added this wall connection to connect the porte-cochere to the principal structure. And so now, as it being connected by this wall, it meets the letter of the intent of the ordinance. And so it creates now sort of one principal structure where this can be administratively approved. And so there's just some conflict there, and that's why we thought that we could look at this a little further. The concerns that the Architecture Review Board brought, which I thought were valid, and reason why I'm not asking for a recommendation today, there might be some unintended consequences just based on design and restricted covenants based on different neighborhoods, that kind of thing. And so honestly, I think we would also look at this entire section, not just the accessory, but the entire use section of accessory uses. And so I ask that we'll probably just take a pause and study this further. So I'll ask a couple of commissioners to join sort of a work group to just to study this a little further with representatives from the Architecture Review Board. If you guys want to, Amanda or Mark, want to come and share anything, you can. Unless y'all had specific, do you have specific questions for the Architecture Review Board?
The question I have is that, explain it to me, I've got lost a little bit. Why are they doing it? So, because they get administrative approval as opposed to having to go
Correct. So you would get an administrative approval opposed to going through special exception to the Board of Zoning Appeals.
It's a backdoor.
So you're trying to avoid the Board of Zoning Appeals.
If I were, yes,
That's what it appears to be.
yes,
But it's still got to go through the Architectural Review Board though, right?
yes. The Architecture Review Board, Board of Zoning Appeals, two different entities.
understand.
Yeah.
Goes there first, yeah.
I understand.
But we need clear
But
rules.
we do have certain neighborhoods. like-
Please go to the podium. Thanks, Amanda. They can't hear you.
So there are.
This is Amanda Mole.
Yes, thank you, Fred. Sorry, I didn't introduce myself. So there are certain neighborhoods that have covenants that encourage separation of buildings and that, we would not want to create an unintentional conflict by what's in an ordinance with what might be in a covenant. So that's one thing. Another thing is that there might be good reason for to break down the massing of a building and not just have one big home, because let's say in this tear down world, you had a smaller footprint home, and there's a grove of trees in front, we may want to actually have the accessory structure more forward to preserve, what's happening on the property. So we thought it would be a good time to, and we appreciate that John was open to this, was to pause, kind of go through the whole ordinance and kind of make sure that whatever you're kind of proposing back to town council isn't creating any unintended consequences, so.
Great, thank you, Amanda.
Sure.
Any commissioner comments at this time?
I do have a question, John. And it relates to, well, I guess it relates to a accessory building that is not part of the main structure. At one point in here in the proposal, for these detached accessory dwellings, you've got a requirement that they shall not exceed 1,500 square foot of heated area. And then in another place within the draft, and that's why, frankly, I agree we should consider the whole thing. It says that there are no utilities allowed in a detached accessory dwelling. And I assume heating is a utility, and we've got to reconcile that, number one. Also, under the current rules, is a gazebo considered a accessory building?
Well, there's a difference between
There's-
different parts of the ordinance.
There's a separation between an accessory dwelling unit and accessory structure. So I think that's part of what we also want to be able to clean up and clarify based on this ordinance as well.
So if we had a gazebo,
It would
typical
be a structure.
gazebo with
That would-
open
that
sides,
it would
wouldn't be a
structure.
dwelling?
It would be a structure.
Okay. Now, what if we had that same gazebo amended, or not amended, modified and closed in? Would that become a dwelling?
Not necessarily. I mean, based on the sizing, I don't think your gazebo would meet the merit. Unless I'm envisioning not a gazebo, so you have
Well,
something.
there's one example you can look at. Go right down Governor's Drive and take a look.
Look left.
It was an open gazebo, and now it's a closed, almost looks like a studio. Now, whether it's a dwelling unit, I can't tell you. I don't know what's inside. But I didn't see any ARB construction signs up, so I don't know what the approvals were.
There's three different categories in the ordinance. There's the dwelling unit portion, the accessory building portion, and then the accessory structure portion. They all sort of work together, but there's some disconnects between them, so I think it's.
But if it was not a dwelling unit, you would not be able to have any utilities running to it or anything else.
So so you're saying like restroom, bathroom, that kind of thing. That's essentially what we would adhere to a dwelling unit having.
If it's a utility, yeah.
Yeah.
I mean, that's what the language says. That's why I think, and I agree with you, we gotta take a look overall to see exactly what we're talking about. I know when this ordinance was picked up, probably in total from the county ordinance, there wasn't much attention paid to the detail.
Okay, so we're gonna work on it, eh, John?
Yes.
Okay, super. The next item on the agenda, item 7, correspondence, staff comments. John?
I have shared with you just sort of a monthly update. I just want to highlight a few things for your attention. Yesterday at Town Council, Council did approve RFP for a feasibility study analysis for a performing arts cultural center. And so that was approved by council yesterday. We are well underway with our marsh management plan. I spoke with our consultants this morning. They have put the initial or preliminary recommendations out to our stakeholders. And so they're sort of batting a hat to kind of narrow those comments received from the various stakeholder groups. And we'll have that come back hopefully in October, but really allow the public to have one more look at that before you guys see it for a recommendation. But I'm excited about the list of 4 things. They're kind of broken down into 4 categories where we'll be able to monitor, restore, protect, and then sort of engage or educate based on their list of recommendations. But those preliminary recommendations have been shared with the community. We had well attendance from our charrette during the morning with those stakeholders, and those entities provided a good amount of feedback to our consultant team. Regarding our comprehensive plan update, we're working through some onboarding documents just to get started, but I anticipate